Hi everyone, Assalamu alaikum. This is Nahid and welcome back to my video once again. This one is the continuation of previous couple of videos on cross-border commercial agreements, and today I'll try to throw some light on the Chinese jurisdiction, as I have talked about the US jurisdiction and UK jurisdiction in my previous couple of videos. You know that the government of Bangladesh is having a very good relationship with the government of China, and at the same time, the China has a very big market in Bangladesh, and thousands of contracts, in writing or online, is taking place every day with the Chinese parties, and that's why I think it's important to talk about the legal system of China regarding the international commercial transactions. And to talk about the battle of forms, it's required that according to the Chinese contract law, there should be a proper offer and a proper acceptance and consideration for constituting a good contract. In case of battle of form, as I've said earlier, that one party, suppose a supplier, sends a form of contract to the other party, the other party puts some changes on that and send it back to the first party. This is the way the battle of forms actually take place. And in case of China, we have seen that the court will look at the materiality of the changes that the other party puts. That is, suppose a supplier sent me a form of contract and I put some changes. The courts in China will look at whether the changes I put are material or not. If the changes are material, then it will be counter offer. But if the changes are not material, then it's acceptance. And in case of materiality, I've seen that the subject matter of the contract, quality, quantity, time frame, place of performance, obligations of the parties, dispute resolution. These are the matters that are taken as material. So if I put some changes regarding these matters, then that will be counter offer. Otherwise, if the changes are very simple and it doesn't hit the core of the contract, then that's acceptance actually. So China is having a different kind of battle of form, very unique and different from what we have seen in some other jurisdictions like USA, UK, Australia, and Germany. Language is a very important fact, as you said, as I've said earlier, that in some jurisdictions, if you go for court litigations, everything should be written in that local language. Suppose if you go to Japan and you go to court for any dispute between the parties and the counterparty is Japanese, everything should be written in Japan. Even you enter into a contract and the whole agreement is written in English, you have to translate that whole agreement into Japanese language, and then you should go to the court litigation. So this is the way some jurisdictions are having very conservative attitude regarding language. Although in China we have seen that some language specific contracts should be written in Chinese language, especially the contracts relating to government. And the courts are quite reluctant in reviewing the contracts which are written in foreign language. So in this way, it's very important to think about the language you are keeping in the agreement. Regarding online contract, as I have said earlier, that thousands of contracts are going on online each and every day with Chinese counterparties, and the court will look whether there is a very good offer and acceptance and consideration, and that will be a very good contract. And it doesn't matter whether the contract is written or is on internet; it doesn't matter. Regarding implied contract, like some other uh, countries, USA, UK, the same thing is also here, like the other common law countries, that there are some implied contract regarding the quality of the products. Suppose you don't put any provision regarding that, but the quality of the products must be uh, very good and acceptable. In USA jurisdiction, we have seen that there are some implied contracts, there implied terms of agreement, that the product should be merchandisable and they should be fit for the purpose of the contract. So in this way, some in some jurisdictions, the quality of the products are ensured by implied terms, and uh, there is nothing about avoiding that. And in case of Chinese jurisdiction, we have seen that if there is nothing written regarding the quality, the parties are free to enter into a supplemental contract and put some provisions regarding the quality of the products. And in case of Vienna Convention, we have seen that China is a party to the Vienna Convention, what is known as CISG, but China has put a uh, reservation on Section 11B. Section 11B of CISG says that if a party, if a country is not signatory to the CISG, a party of the country may be uh, liable to comply with the provisions of the CISG if the private international law requires that. But to avoid this complexity of application of private international law of that particular country, China has put some reservation. There are some other countries who have put this reservation to avoid this kind of complexities of private international law in case of applying the provisions of CISG. Regarding good faith, we can see that good faith is a very essence of international commercial transactions. From the very Middle Age, the English courts were facing a lot of international commercial litigations, and there were some separate courts for international commerce. There were some separate laws and rules and regulations, and they were very easy and not very complicated. The courts didn't go very deep into the complex question of laws and other complex matters, and it was very easy for the parties from whole world to come to the court and do the litigation. And in all these cases, good faith is very important. Good faith is something that a person of natural general prudence should do on certain circumstances. What is known as the reasonable person should do. So, what is the reasonable person is a very good question in law, because in some very renowned cases, the reasonable person has been discussed. As we have seen, the reasonable person is a person sitting on the Clapham omnibus, as we have seen in the Wednesbury reasonableness test. So, a person having a prudence of some other general persons of a society is known as the reasonable person, and the good faith is something like what someone in someone like a prudent person should think about, should do, is required for the good faith. Like some other jurisdictions, there are some provisions for termination of contract, and we can see that in China, the parties can only terminate the contract with mutual agreements and negotiations. But there are some circumstances when the parties can terminate the contract, and they are when the contract objective cannot be realized owing to force majeure. Prior to the expiry of the period for performance of the contract, one party makes it clear that it will not perform its major obligations. One party delays the performance of its major obligations and fails to rectify its default within the given reasonable period of time after being requested to perform. and the objective of the contract cannot be realized because of one party's failure to perform its contractual obligations or any other breach of the contract. So these are the factors when the parties can terminate the contract. And in case of termination of contract for financial distress, we can see that in China, uh, one party can terminate the contract for the financial distress of other party and send the other party a notice to pay some security, so that the other party doesn't become a defaulter later on. This is quite different from what we have seen in USA and UK jurisdiction. And USA jurisdiction, we have seen that if the party who is facing financial problem and going down day by day, and that party goes to the insolvency court for insolvency litigation, then the other party has no right to terminate the contract, because the insolvency procedure and involves the insolvency matters are dealt with in insolvency courts, and there are some separate insolvency laws, and so there is no scope to terminate. But if the other party doesn't go to the court and sit idle, then the other party may have the right to terminate the contract easily. There are some circumstances like unforeseeable, unavoidable, and insurmountable circumstances, where these are the scenarios when the force majeure can be effective. Regarding subcontracting, you can see that in China, no party can subcontract with the other parties without the prior permission of the other party, which is also very much unlikely what we have seen in USA and UK jurisdiction. In USA and UK, and the parties were free to subcontract with other parties without the prior permission of the other party if nothing is said regarding this in the agreement. But in China, the parties cannot subcontract without prior permission. Regarding the right of the third parties, we can see that China is having the same law of the right of the third parties. That is, only the persons of the contract can enforce their rights and go to the court for damages, and this what is known as privilege of contract, as we have seen in the UK jurisdiction. Although UK jurisdiction, there are separate laws for the rights of the third parties, but in case of China, there are some situations like in case of subrogation and rescission, the right of the third parties are ensured. Choice of law is very important. In international commercial agreements, the parties sometimes try to avoid the provisions on choice of law, because there are different kind of situations, and in those situations they want to apply their private international law, their own law, to be applied in the contract, but the other party always want their law to be applicable, so they try to keep this vague or not in a complete terms. So, what is required in case of choice of law is the court will look at the foreign elements, and in case of foreign elements, the some factors must be considered. That is, whether any party is a foreign party or resides in a foreign country. Secondly, whether the object of the contract is located in a foreign country, whether the contract is signed, performed, revised, transferred in a foreign country, whether factors that affect the rights and obligations of the parties take place in a foreign country. So these are the facts that should be considered in deciding whether there are foreign elements. And in case of foreign elements, the parties can give foreign law as substantive law for governing the contract. However, in case of some foreign equity joint venture contracts, that means some government contracts with the other governments, in those cases for exploitation and development of natural resources, the governing law must be China, and foreign law cannot be chosen in governing the agreements. So, in case of a choice of jurisdictions, the parties can keep the foreign law as the governing law, but it should be very carefully written. The courts of China are competent, and the government is also trying very hard to make renovation to make the courts more effective. But there are some. It depends on the place to place. Some places they practice the protectionism. So protectionism is something that very important in international commercial transactions, and in those cases, the foreign counterparty may be in some different, not comfortable situations. China is a party to the New York Convention. New York Convention, as I've said earlier, is recognition and enforcement of foreign arbitral awards and interlocutory orders. But China has put a reservation in relation to disputes between foreign investors and the governments of the host countries. And uh, China is a very good place for international arbitration, and many Bangladeshi parties who are dealing with the Chinese counterparties, they also choose Singapore as a good place for arbitration if any dispute arises. And in those cases, there the Bangladeshi counterparties record some very expert persons in international commercial arbitration. And so these are the facts that a Bangladeshi party should understand, should know about the legal system in international commercial transactions that is going on in China. So thank you very much for staying with me, and thank you. Assalamu alaikum.